Uh, I'll just I'll just make sure that we've got everybody out of the waiting room, and I promise you, I will then begin. But it's lovely to see you all, and thanks for arriving on time. Indeed, a minute early. Uh, Okay, good evening, everyone. I will literally just wait for another minute just to make sure that there's nobody still left in the waiting room, and I'll then begin. And if people then enter the waiting room, I will just admit them in dribs and drabs. Okay, so a couple more people. Okay, well, good evening, everyone. I would now like to make a start. So I'm Dan Hill. Many of you I know attend regularly, will have met me before. It's lovely to see you all again. I'm going to be taking you through both of the exercises that we're going to cover today. So I'm going to start with the case and matter analysis, which is a dispute resolution exercise. And I'm then going to go on to the property legal research exercise. I'm not going to show any slides this evening. There are some slides which will be uploaded with the recording, but this is the penultimate workshop. Those of you who attend regularly will have seen multiple sets of slides addressing how to approach case and matter analysis, how to approach legal research. So if I showed you the slides, there wouldn't really be anything new. So I'd prefer to have a little bit more time to answer your questions and also to actually focus on the exercises themselves and the sort of things that I would do if I had to answer these questions. I would like to make a start by taking you through the case and matter analysis exercise. So I'm going to share my screen so you can all hopefully see my desktop. And just before we look at the exercise itself, what I thought we'd do is, rather than me show you the slide, which has got the assessment criteria, I've actually got the SQE2 assessment specification, which is the official SRA sort of Bible that gives you all the key information about the SQE2 assessments. One of the many things it does is it reproduces the assessment criteria, and you can see hopefully that the writing is legible. You can see that there are 3 skills criteria: that you should identify relevant facts, that you should provide client-focused advice, that you should use clear, precise, concise, and acceptable language. And there are the 2 legal content criteria, which you will be very familiar with because they feature in every assessment, apart from interview: that you apply the law correctly to the client situation, and that you apply the law comprehensively, identifying any ethical and professional conduct issues. So if you just keep those in mind, and in fact, I will keep them up. What I wanted to do very quickly, just to put this into a little bit of context, and with apologies to students to whom I've shown this document before, but I think it is quite useful that we spend a minute looking at it now that you're getting closer to the real exams. So this is a document from the SRA website, which is basically designed to help candidates understand what's included in their SQE2 results. Obviously, you guys haven't got any SQE2 results yet because we're looking forward to the exam. You haven't sat the exam, but its usefulness, in my view, is it gives quite a clear explanation of how your actual marks are calculated. So if we take a look very quickly at case and matter analysis, you can see that this candidate, they might be a real candidate, they might be a hypothetical one, I don't know, it doesn't really matter. You can see that they took 3 case and matter analysis assessments, one for business, because there's always a business one for dispute resolution, so it's either or, so it could have been criminal litigation, but in this particular exam, it was dispute resolution, and one for property. Again, it's either or, so it could have been probate. In this particular example, it was property. And what you can see is for skills, there are 3 different marks. So for business, the candidate scored 3, 3, and 4. Same for dispute resolution, and they did a bit better in property. They scored 4, 4, and 4. So these numbers relate to the 3 skills criteria. So, for example, for property, it's probably the easiest one to deal with. For each of those 3 criteria, the candidate was given a mark of 4 out of 5, which shows that they did them not quite perfectly, because that would have been 5 out of 5, but pretty well. You can see that for the 2 legal content criteria, they got 4 for each of those, which is very good. And what you can see in this column is that the skills criteria for the question are averaged. So obviously it's an easy average because they got 4, 4, and 4. So the average is obviously 4. The legal content criteria, so these 2, 4, and 5, are also averaged. Again, it's an easy average because they got 4 and 4, so it's 4. And these 2 numbers are averaged again. So your total mark for the question is the average of your skills mark and your law mark, which again, in this case, was 4 out of 5, which is a good mark because 4 out of 5 equates to 80%, and the pass mark for SQE2 is generally 61, 62, 63, 64. So the reason I'm showing you this is, firstly, so you understand that the total mark that you get, the final mark that you get for any SQE2 assessment is the average of the skills mark averaged with the average legal content mark. I think it's also quite helpful at this stage, as you get closer to the real exam, to be able to visualize how you're going to approach these assessments. And I think one of the things that you might find it helpful to visualize is when you're actually thinking about these criteria, you want to be thinking, ideally, I'm going to average 4 out of 5 for each of these things, because that's how well I'm going to do them. As far as the law is concerned, typically the legal content marks that students get are lower than the skills marks, but I think it's good to aim high. So if you aim to average 4 out of 5 for skills, that's pretty good. You can see that this candidate did manage to average 4 in 2 assessments, and they even averaged 4.5 in a legal research assessment. But I would say, and again, with apologies to those of you who have heard me say this before, that if you can make sure that your average law mark is 3 or better, then generally you will always pass. Because if your average law mark is 3 or better, chances are your average skills mark will be 4 or maybe 3.8. So if your average law mark is 3, the chances are that your overall average is going to be closer to 3.5 out of 5, which equates to 70%, which is always going to be a pass. So as I say, with apologies to anyone who's seen me talk about this document before, but I do think it's important not just to look at the assessment criteria, but to look at how the assessment criteria actually combine to produce your overall mark. So what I now want to do is I want to take a look at the question itself. I'm going to minimize these. We'll come back to them when we come to look at the research. I'm going to open up a blank document, which we will pretend for these purposes is the answer template for the case matter analysis. And I'm just going to explain for a few minutes before I take questions what sort of technique I would use if I was having to answer this type of question in the real assessment conditions. So what I would do is I'd read through the question and the facts. I'd also look at the attached documents, the various emails that we have. So we'll just pretend in the interest of time that I've done that. Once I get to the end of the document, I would focus on the advice and analysis required. So what am I actually expected to include in my answer? So JS, who is the client, would like our advice on IH, Ilkley Hotels, position, what options are open to them, including whether they are obliged to pay the contractual price now, what the legal and or practical steps, blah, blah, blah. If you're lucky, you'll have a nice numbered list of points, which is a little bit easier to copy and paste. But what I would still do is I would copy from the instructions, I would paste into the answer template. That's a weird font and it's very small, so I'll just put it into Arial and I'll increase it a bit. So I would paste these into my answer, and I would use these as the sort of first draft of subheadings. And what I would do, because we know that the legal content marks are the most difficult ones to obtain. So I want to make sure that there's sufficient legal content in my answer so I can score average 4 out of 5, ideally, but no less than 3. So what I would do is I would literally, by reference to these subheadings, start to make a note of the legal points that I would include in my answer. So focusing on the key legal content points, I might start by saying appears to be a contract in place because the evidence seems to suggest that there was a contract and clearly the software has been written. So as far as our client is concerned, there's been a breach of contract because they haven't got what they wanted. And whenever there's been breach of contract, you need to work back to think what were the key terms of the contract and which of those terms have been breached. So I would say that there seems to have been an express term that software would integrate with Ilkley Hotels' existing systems and that it would update room availability in real time. I think there's also likely to be an implied term because this is a business-to-business contract. So I would say that there would be an implied term that service, and we had some questions about this morning in terms of is software a good or is it a service? I think arguably it could be both, But in my analysis, it's slightly closer to being a service than a good because I don't think there's a tangible good. But if you thought it was a good, it doesn't matter because there would also be an implied term. But my analysis would be it's more likely to be a service. There's an implied term that the service be provided with reasonable care and skill. My analysis would be these terms have been breached because software is not updating in real time and bookings therefore being lost. Therefore, client is not currently obliged to perform its part of contract to pay the purchase price. So this is somewhere between notes and a proper answer. Obviously, I would tidy this up, but what I want to do now is I want to try to get the legal content points down. Because I think if I do this now, I can satisfy myself that I've got all of the points, and it's then, in my opinion, easier to spend the rest of the hour tidying your answer up than it is to be trying to think, are there any other points that I should have made? So that's the first subheading. I'm not going to keep this as a subheading. I would refine it. So I might call it something like legal analysis of Ilkley Hotel's contractual position or something like that. But I'm not going to waste time tidying it up now. I'm going to move on to the next area, which is the options available to them. So we've kind of covered the first option already, which is not obliged to pay price till the software company, that's an abbreviation, can demonstrate system is working properly. However, there's clearly a dispute. So dispute needs to be resolved. So how could we do that? We could check to see if there is an arbitration clause. If there isn't, we could propose ad hoc arbitration. So normally, if the parties want to arbitrate, there's a clause that they agree in advance in the agreement saying that's what they'll do. However, even if there isn't an arbitration clause, the parties could still subsequently decide that's what they want to do. Or we could propose something a little bit more straightforward like mediation. What else would we do? In most dispute resolution cases, we want to obtain more evidence, and I think that this is no exception. So I think we would obtain a more detailed statement from the client as to his dealings with SS. So we have a more detailed view than we have from the relatively small number of emails we've seen from the client's perspective in terms of precisely what was happening between these parties. Finally, because I want to make sure we have time for questions, if we're thinking about legal and practical steps, I think there's an important legal point here that it is not appropriate. So we would probably, what would we do? We'd remind SS that not appropriate to threaten proceedings as they have not complied with a pre-action protocol. What should they do? They should send a letter of claim if they really think they're entitled to the money, and participate in ADR. So I could carry on, but I want to make sure we've got time for questions. And I think what you can hopefully see is that I've built up a decent number of legal content points. So I'm satisfied that I've captured most of the legal content points. And what I would do now is I would edit this so subheadings are a bit more focused, and so the content reads slightly more professionally, and that's what I would spend the rest of the hour doing. So if we just pause there and I stop screen sharing for the time being, is there anything that anyone would like to ask, either about the exercise itself, about case matter analysis generally, or about the way that I'm suggesting you could approach it? So I can see that there's a question from Daisy in the chat. So if you just bear with me, I'm just going to look at that. So Daisy, is the implied term of carrying out the service with requisite care and skill a condition or warranty? That's a very good question, Daisy. I think off the top of my head, I think it's actually an innominate term. So I don't think it's actually expressed within the statute to be a condition. So I think it would depend how serious the consequence of the breach was. If anyone else knows better, then please correct me, but I don't think it's defined as a condition. So I think it would generally be an innominate term, which, if you recall, is the intermediate category where it could be either, but you have to look at the consequences of the breach and how serious they are. Anyone else have a question about this particular exercise?
I
Good.
do. Oh, sorry. Can you hear me?
Yes, I can, Becky. Go ahead, please.
I got I think I just got a bit bogged down, but the question or the instruction in terms of what can he do to protect the company's interests, I almost wasn't sure if that needed like a separate subheading, and I wrote it as a subheading and then didn't fill it out, and then the exemplar didn't either. Was there anything that we could have said on that, or was it just generally like what are the options?
Yeah, I think it's really, and you're right, Becky, excuse me. I think it is slightly ambiguous. I'll fess up and say I actually wrote this exercise, so I'm the person to blame. I
No
think
blame, no blame. I just want to understand.
Yeah, but no, it's interesting. But I think in practice, people often talk about, protecting the client's interests. But I think what it really means is what options does the client have? Because I think obviously it's implicit, if the solicitor's doing the job properly, that they want to advance and protect the client's interests. So I think that's really just a sort of a more circuitous way of saying what options does the client have, and what should they do to take this thing forward. So I don't think there's sort of anything different to that you needed to address.
Okay, thank you.
Good. And Dania, how long would you roughly spend reading the material at the start? It's a good question, Dania. So case and matter analysis, you do have an hour. So it's not like the writing assessment where realistically you've probably only going to got 2 or 3 minutes to actually read the question and any accompanying material. So I think obviously it depends a little bit how much we're talking about in terms of attachments. I would think that sort of anything up to 10 minutes reading the question, including the attachments, would be absolutely fine. I think that, again, I think you could probably spend another 20 minutes sort of doing the exercise that I've been doing if you do favor the approach. I mean, it took me about 10 minutes to kind of get this far. So, and I was sort of talking and typing at the same time. So I think if you spent 20 minutes, you could get quite a lot of the content down. And I think that would still give you half an hour to correct typos, to improve the English, and, you know, to generally polish the work. So I would have thought that the timings would be of that order, if that makes sense.
Perfect. Thank you, Dan.
Great. Anyone else like to ask anything about this exercise? If not, it's not a problem, because we could obviously go on to look at the research exercise. Okay, what I suggest is we take a look at the research exercise. If anything occurs to anyone about the case and matter analysis, obviously it is just me, so I'm happy to take additional questions on the CMA. So if I just get rid of document 6 for the time being, if I get the specification back up, all I would like to do is to take, I'm going to do another screen share. And before we look at the research exercise, I'm just going to take you through the assessment criteria for legal research. So again, just like case and matter analysis, there are 3 skills criteria and the standard criteria for the application of law. So the 3 skills criteria are that you should identify and use relevant sources and information. Secondly, that you should provide advice which is client-focused and addresses the client's problem. And thirdly, that you should use clear, precise, concise, and acceptable language. So I think it's worth just talking very, very quickly about these skills criteria. So if we look at the first one, to identify and use relevant sources and information, I think that what this is getting at is what you will have, as you know, within the legal research question, is you will have a series of resources that you'll be given that will appear as attachments to the question. So some of them will be extracts from textbooks, secondary sources. The rest of them will probably be primary sources, so extracts from statutes, statutory instruments, possibly case law. So what this criteria is measuring is, when you give your advice in your answer, do you reference that advice against the relevant sources and information? Because if it's a legal research exercise, what the reader is looking for is they're looking for the advice, which ideally will set out the answer to the question, but they're also looking for the authority, because they don't just want to rely on the fact that you're telling them that this is the answer. They want to be able to check that this is actually the applicable law, for example, by looking up the relevant source. Providing advice which is client focused and addresses the client's problem, I think that that's clear. Again, it's slightly confusing in the legal research assessment, because the question will nearly always be in the form of an email from a partner, and the answer template will generally be an email back to the partner. So although you're not actually writing to the client, unlike the writing assessment, for example, where you generally will be, the idea is, even if you're writing to the partner, you should still provide advice which is client focused and addresses the client's problem. And using clear, precise, concise, and acceptable language, I think it's fairly obvious what that means. So what I thought we would do is take a quick look at the question itself. And I would start by just explaining how I would go through the question itself. Jenny is just saying, sorry, I'm just looking at the chat. Were the two assessments assigned in separate weeks? The answer is yes, but Becky has very kindly got in there ahead of me and confirmed where to find them. So thank you for that. So if I just leave the chat open in the corner, just so I can keep an eye on that. So if I minimize that, I can go, that's actually the attachments. So there is a question, but I think in order to get to the question, yeah, I just need to close that. So obviously, for legal research, the first thing to do is look at the question, make sure you understand the question, and then think about looking at the various sources that you're given with the question. So we're told that the company, who is the client, is currently in occupation of an industrial unit under the terms of a 15-year lease, which was granted to the company. So we're not actually told that the company is the tenant, but I think it's implicit, and sometimes you do have to read between the lines, that if the company is occupying the industrial unit under the terms of a lease, then to all intents and purposes, that's telling you that they are the tenant. The company intends to assign the remaining terms of the lease as it's experienced rapid growth and now wants bigger premises. So again, sometimes in legal research, you need to use your underlying legal knowledge to interpret the question. So the concept of assignment, I'm sure you're all familiar with. So if you're a tenant and you have a 10-year lease, for example, and you decide after 2 years that you need bigger premises, what you would do is you would try to find someone else who wants the remaining 8 years of the lease. And if you are able to transfer the remainder of the lease to the other party, that's what's technically known as an assignment of the lease. So the landlord has told the client that consent to any assignment. So again, this is where your background knowledge of property law is important, because as a general rule, if you want to assign the lease as a tenant, there's generally a clause in the lease that says you can only do that if you receive the consent of the landlord. So the landlord has told the client that they won't consent, or they will only consent on the condition that an authorized guarantee agreement is completed. You're told that that's correct because the terms of the lease have been checked and the landlord can insist upon an authorized guarantee agreement. So that's the background, and it's important to use your underlying knowledge to understand the background. You're then asked to please conduct some research using the sources provided and prepare advice for the client covering the following 3 points. And you're specifically told to include, for my reference, your legal reasoning mentioning any key sources or authorities. So again, what I would do if I was answering the question, and I'm not actually going to do this because it's obviously exactly the same process that you've seen me do once already, but I would actually copy these subheadings directly into my answer, firstly, to save time, and secondly, because if I can see the 3 areas that I need to address in the answer, that's a good visual cue that's going to help me manage the time. Because if I can see that I've got 20 minutes left and I'm still addressing point 2, that's a pretty good indication that I really need to finish point 2 and start addressing point 3. So obviously the key to legal research is to look at the sources that you have. So if I click on here, that opens up a separate window and I can see that there are 3 separate sources. First one is an extract from Halsbury's Laws of England. The second one is an extract from the Landlord and Tenant Covenants Act 1995, or rather, sorry, Landlord and Tenant Covenants Act. And the third one, rather confusingly, is an extract from a very similar act. So I can immediately see that the first one is a secondary source because I know that Halsbury's Laws of England is effectively a textbook, so it's a secondary source. And I can see that these 2 are primary sources because they're both statutes. So I think it's worth saying that it's relatively unusual that you would have as few as 3 sources. If you think back to the practice feedback activity you did, which was all about limitation periods, from memory, I think you had more like 6 or 7 sources. For those of you who've looked at the SRA sample legal research question on the SRA website, the one about the dangerous dog that bit the postman, again, I think there are more like 6 or 7 sources. So in terms of what to expect, in the exam, I would say 6 or 7 is probably more typical, but that doesn't mean that 3 is a bad thing, because whether you have 3, whether you have 6, whether you have 8, the basic approach that you should take is exactly the same. So the approach that I would take personally is I would always start by looking at a secondary source. So even if there were multiple other primary sources here, I would always start with a secondary source. And the reason that I do that is secondary sources are written in such a way that they're used by busy practitioners who want to be able to find the answer to a particular question quickly. So I think, and I've just seen Alicia's question, I'll answer that in just a moment, Alicia. So I think that the advantage of secondary sources is they're generally the quickest and easiest way of finding an answer to the question. Once you know the answer to the question, that's a good thing. Firstly, because it enables you to write the advice. And secondly, even though you're still going to have to look at the primary sources because you need to be able to reference the relevant sources, generally speaking, if you already know the answer to the question, it's actually much easier to reference the primary sources. I think the problem is if you start looking at the primary sources, you can often get stuck in material which is quite dense and it can take you some time to read, and it's not always clear to what extent that particular primary source is helpful or not. Alicia's question is whether the sources appear in a similar way in the exam. And I think it does make sense. I normally answer questions at the end, but I think it does make sense to actually answer this one now. So what I'm going to do very quickly is I'm going to leave where we are and I'm going to actually go and look at the SQE2 sample questions that I'm sure you're familiar with. And if we actually go all the way to the bottom of the screen where it says learn more, we can actually look at the sample assessments as they appear in their actual exam format. So legal research is actually the 3rd assessment. So you'll just have to bear with me as I click through. So yes, I would like to end that. we're going to fast forward through the legal writing as well. Good. So we're now looking at the legal research question as it will appear in the real exam. So you can see that the question itself concerning the dog that bit the postman is on the left-hand side of the screen. What you can see is actually at the bottom of the question, there is a numbered list of attachments, Alicia. So I think that's the answer to your question. And again, it's quite helpful because you can see which of these are secondary sources and which of them are primary sources. The first three are all secondary sources, which I think probably means that the convention is that secondary sources would normally be listed first. And you can see that 4, 5, 6, no, sorry, you can see that 6 is also a secondary source, but 4, 5, 7, and 8 are primary sources. And in terms of how you would access the sources in the exam, you can see that there's an attachments tab, and again, they're tabbed. So actually, you really need to be able to look at this and the list together to know which tab you want to select. Good. So I hope that's helpful. So if we go back now to the, oh, that's the wrong question. Yeah, if we go back to this, what I would do is I would start by looking at Halsbury's Laws of England. So that's going to open in a separate window. So what I can do is I can separate that window, and if I reduce the size a bit, we should be able to look at that and look at the question at the same time. So we can remind ourselves what the question actually is. So reading sources is a little bit challenging in the context of legal research. The reason it's challenging is because there's often quite a lot of information, and you'll often be given more of the source than you actually need in order to be able to answer the question. So what Kaplan are doing is they are effectively testing your ability to skim read and to ascertain how much of this source is actually relevant. So there are obviously lots of different ways in which you can read a source in order to get to the relevant material. And you may all have got your own technique because you've obviously had the opportunity to do this with the self-practice and the practice feedback activities. Personally, the way I would do it is I would look very quickly and I would kind of focus on the subheadings. So I would see, for example, that the first subheading we have for paragraph 382 is the unreasonable holding of, the unreasonable withholding of consent. And I would ask myself, does this seem to be a problem which revolves around the unreasonable withholding of consent? And I would say, I don't think that's really an issue in this case, because yes, the landlord has said that he will withhold his consent unless an authorized guarantee agreement is completed. But we're also told in the instructions that the partner has checked the terms of the lease and the landlord is permitted to do that. So to me, this doesn't look like an obvious case of unreasonable withholding of consent. So rather than try to make sense of this rather dense looking paragraph, I would simply scroll through, because if I'm wrong about it and I get to the end of the extract and I still haven't found anything relevant, I can always go back. But what I want to avoid is kind of getting stuck somewhere here when it's perfectly possible that actually none of this really matters because this isn't a case of unreasonable withholding of consent. So I would simply fast forward. So these are now footnotes, which are all to do with the material that we've seen above on unreasonable withholding of consent. There's also something on enforcement of covenants. Again, I would kind of trust my judgment and say, based on my analysis of the problem, there doesn't seem to be an obvious issue with enforcement of covenants. So let's just click through. What we now get to at paragraph 484, because each of these paragraphs is essentially a new topic. So this is now the third paragraph we've looked at. And this is starting to look a little bit more promising because it's talking about tenant guaranteeing performance of covenants by the assignee. So I would say the reason that this is potentially more relevant is firstly, because I could already see that if I read 3 lines down, there is a reference to an authorized guarantee agreement. If I use my powers of lateral thinking, I can see that if it's an authorized guarantee agreement, what does that mean? What it really means is that the tenant, our client, is guaranteeing that the new tenant is going to perform the covenants. And again, based on my knowledge of property, particularly commercial property, one of the more important covenants in the lease is that the tenant pay the rent. So that's my reasoning, apart from the fact that I can see a reference to authorized guarantee agreement as to why paragraph 484 is much more obviously relevant than the information which we found up until now. So I'm now interested, so I'm going to slow down and I'm going to read this properly, and I can see that where on an assignment a tenant is to any extent released from a tenant covenant of a tenancy, nothing in that act precludes him from entry into an authorized guarantee agreement with respect to the performance of that covenant by the assignee. For these purposes, an agreement is an authorized guarantee agreement if under it the tenant guarantees performance relevant covenant, blah, blah, blah. It's entered into in the following circumstances. So what we can see already is that we've basically kind of got an answer to the first question, because the first question was to explain what an authorized guarantee agreement is and who should be a party to such an agreement. So I could either express it in my own words, which is probably easier, or if I wanted to, I could copy and paste into my answer, but I'd have to do quite a lot of editing in terms of getting rid of the footnotes and so on and so forth. So I'm conscious of the time and the fact there are probably questions. So I'm not going to carry on with my method, but I know from other research sessions that I've led that one of the things that people find hard is what source should I start with? How should I avoid getting bogged down in relevant sources? And hopefully that gave you some idea of how you could go about doing that. So just before I answer Alicia's question, which is a good one, what I thought I would do, because this may be helpful for other people's questions, is to actually access the exemplar. So the exemplar for the exemplars, plural, excuse me, for the legal research activities appear in a slightly different place to usual. I'm sure you all know this, but just in case you've missed it. So they actually appear on the resources. The reason they're in the resources is because the format of the answer for legal research was updated by Kaplan after the start of the course, which meant that Barbary had to reproduce the exemplars, so they were in a slightly different format. This is where you'll find them. So this is the exemplar for this exercise. And just before I go to questions, what we can see is the answer to the first issue is that in leases granted on or after January, on assignment of lease, the outgoing tenant, the assignor, is relieved from any obligations in respect to tenants' covenants under the lease. And there's the reference to the Landlord Tenant Covenants Act 1995, Section 5, because that's the legal authority for that proposition. However, if such a lease, when granted, contained an express condition that in order to gain the landlord's consent, the assignor would have to enter into an authorised guarantee agreement if requested to do so by the landlord, the assignor would be obliged to do so, and so on and so forth. So what I'm going to do is I'm just going to pause there because we've only got 10 minutes left, and I do want to make sure that we do justice to any questions. And I can see that we've got a few questions. So the first one from Alicia. Even if you know what an AGA or authorized guarantee agreement is before looking at the sources, should you still be referring to the relevant statute, i.e. if you missed the statute, just gave a definition, would this lose marks? Yeah, I think ideally, Alicia, you would refer to the statute because generally speaking, for most SQE2 assessments, as a candidate, you're not expected to cite legal authority. But I think the legal research is really the exception. So although the partner wants the answer, so they want to know what is an authorized guarantee agreement, this sort of referencing is important because rather than just take your word for it, this is an authorized guarantee agreement, this is the legal position. They want to be able to see what primary source actually supports that position. So I think the referencing of the sources is actually quite important. And obviously, one of the things that we saw when we were looking at the assessment criteria earlier is that one of the skills assessment criteria is that you should refer to relevant sources. And in terms of legal content, so identifying the law correctly and comprehensively, I think that identifying the correct source would also count as a legal content point. So just before I take Kate's question, I'll just take Alicia's second question just because it follows on rather neatly from the first question and what I've just said. So the second question is, can you reference sections of law by saying Section 2 of the Act states that instead of referencing in brackets after the legal point? Yeah, I think you can, absolutely, Alicia. I think it's a matter of personal preference. I think the only thing that's important is that it's readily discernible what section of the statute is the authority for the proposition. So if you want to do it the other way around and say Section 2 of the Act states that, rather than state the position and then say brackets Section 2 of the Act, I think that's absolutely fine. I think either works well. So just looking at Kate's question, I seem to be missing really obvious points. I think because I'm just thinking it's assumed. In this exercise, I assumed about tenancy being made after 1996 and didn't include that part because we're told it's from 2010 and you did something similar in the last exercise. Do we need to be really clear on every single point, even if it seems obvious and probably would be known by the partner? Yeah, it's a good point, Kate, and I'm sympathetic because I think it is easy, particularly when you're working under time pressure, to just skip these things because you assume that they are obvious. I think if in doubt in SQE2, I probably would make those sorts of points, just because I think the assessor might look upon it as being a clearer piece of advice if you make it clear that this applies to tenancies made after 1996. So no matter how hard you try, the chances are you're not going to make every single point. I'm not saying that you'd be penalized for every omission, but I think if in doubt, it probably is worth doing that. So Alicia says she has same issue. Is it not irrelevant when we're told it's 2010? Yeah, I think arguably it's irrelevant, Alicia. I think it's I think it's a question of degree, to be honest. So I wouldn't write very much. I think what you could say is you could almost make it a little bit more practical than the wording of the exemplar. So the exemplar says in leases granted on or after January 1996. So you could almost, if you wanted to, you could make it a bit more practical and say as the lease was granted after 1996 to make it clear that you're actually referencing the fact rather than doing it that way. Jenny, the point saying that the AGA is a contract between the landlord and the assignor is not mentioned in the sources. Are we expected to add information from our knowledge on top of what is included in the sources? So yeah, again, Jenny, I think it's a tricky one. All I would say is I think that the advice should be clear and the advice should be in a format that the client could follow. So I think the client would almost certainly find it easier to understand what an authorized guarantee agreement is if you say, look, essentially it's a contract between you as the party assigning the lease and the landlord, and you're basically guaranteeing the rent if the person to whom you assign the lease for whatever reason stops paying the rent. So although it doesn't actually say that in the sources, I think you could probably infer from what we saw in Hallsbury's that that is the purpose of an authorized guarantee agreement. So I think if you can express yourself in a simple way that the client is more likely to understand, even if that means inferring what something is from the sources, I think that that's a good tactic to adopt. Yeah, so I think there's a little bit of debate, a good debate about whether it involves the assignee and confusion with a license to assign. So I don't think it does. So I think the authorized guarantee agreement is simply an arrangement between the landlord and the assignor. Again, if you think about it, it kind of makes sense because the landlord will probably have credit checked the original tenant as part of the due diligence before it granted the tenancy to the original tenant. So the landlord knows that the original tenant is good for the money. The landlord doesn't know who the assignee is and may be concerned that the assignee isn't as good a credit risk as the original tenant. So I think that's the sort of the rationale is that if the original tenant is still guaranteeing the rent, then the landlord can't reasonably object on the basis that they're concerned that the rent might not get paid. Okay, so we're almost out of time. Would anybody like to ask a final question? Okay, well, listen, I hope that was helpful. It's been great to see you all. There is one final workshop next week, but I'm not doing it. So I've got something else I need to do. So it's been great getting to know some of you over the course of these workshops. So I'd like to wish you all the very, very best of luck in the mock exams. Obviously, in the real exams following those. I have just seen your question, Gabby, so I'll take it. How important is it to include a separate paragraph with a conclusion? Um, I think it's helpful, Gabby, but I don't think it's essential in the sense that I think if you've got three separate issues, provided you've expressed a clear conclusion at the end of each issue, I think that's fine. I don't think you need to come back again and have an overall conclusion, although I don't think it's wrong to do that. So for those of you who are saying thank you from me. You know, it's a real pleasure to do these workshops. I am actually doing some mock assessments, so it's not beyond the bounds of reason that I will be doing your mock assessment, in which case I look forward to seeing you then. But, you know, best of luck with everything. And I genuinely hope that when you're sitting in the Kaplan test center, something that you've learned, something that you remember from one of these workshops will come back to you and will help you. And if that happens, then, you know, it will be very well worth the experience. So thanks again. Best of luck with the mocks and the real exams.